In nearly every trust or will contest case where you're challenging a document based on lack of capacity or undue influence, you have got to have an expert witness. The reason for expert witness is that you need to be able to present to the court medical information if you hope to win on a lack of capacity claim or an undue influence claim. The medical information of the decedent is critically important because it's one of the necessary elements to prove either lack of capacity or undue influence. The problem is that a majority of the information that you want to present to the court out of medical records is hearsay. Hearsay is an out-of-court statement used in court to prove the truth, and it is especially a problem when you have diagnoses in medical records. So in California, anytime a doctor diagnoses a medical condition such as dementia, Alzheimer's, anything like that, that is hearsay evidence, and you're not going to be able to admit that evidence in court just by showing the court the medical documents. But instead, you can retain an expert. The expert has the right to review all of those medical records, all of that hearsay opinion, all of those diagnoses can be reviewed by the expert, and then the expert can use that information when they give their opinion in court. That doesn't mean that the expert can repeat what's in the medical records or read the medical record into the trial, but what the expert can do is say, I've looked at all of this, and in my opinion there was a lack of capacity, or in my opinion there was a susceptibility to undue influence, and I'm basing it on the medical information that I reviewed. If you have no expert, you have no medical evidence to present to the court, and that means you probably have no case.